All right, in our last video, we talked about how investors could benefit from having internal control and governance clauses. In this video, we'll be talking about how to protect the investors' investments using a combination of methods. In this video, we'll be talking about the investors' participation in future fundraising, restrictions on the transfer of shares, as well as preemptive rights. We'll have another video where we'll talk about exit rights and preferred payouts for investors, right? So, mind you, our investor, a private equity or a venture capital investor, they have chosen to invest in a particular company because they want to have their share valuation um, increased, right? They are expecting that the price of the shares that they have subscribed to or they have bought, that they will increase at a later stage and that they will be able to sell those shares at a higher price. Now, the entire gamut of investor protection rights, the entire bouquet of investor protection rights, um, makes sure or ensures that as much as possible that there are that the investors investment is protected, right? All right, so let's look at future investments. Now, we know for a fact, and we've discussed this in the past, that any future investments into the company after this round is that will be sort of will dilute the investor's investment down, right? So, for example, let's say the investor has 27% and fresh shares are issued to a new investor, right, in a round two. In which case, our investor in round one, that 27% will get diluted down. By how much depends upon the number of new shares being issued. Now, we know for a fact that that there are that you will require a special resolution as and when you're issuing fresh shares, right? But what happens when, let's say, you're at 27 or 26% and you get diluted down to 23%, right? Immediately, all the benefits that you were getting in terms of having a 26 or a 27% shareholder, meaning which you could stop special resolutions, all of that stops, right? That's one. Second is that at some point of time, as and when the investors' equity gets diluted down to a greater extent, let's say 5% or 10%, you might lose all of your rights in its entirety. Let's go over this in a little more detail. So, an investor who's, let's say, at 23, 24%, they may want to put in a clause into the reserved matters saying um, that if there is going to be a further issue of capital, that an affirmative consent of the investor will be required, right? Now, so in other words, any further issue of capital becomes a reserved matter, right? And it is advisable that any further issue of capital, irrespective of whether your investor is above 27% or below 25%, irrespective, it is always advisable to have an affirmative voting right on further issue of capital, right? Now, is this enforceable? Yes, it is. According to the Karnataka High Court in IT Cube India Private Limited, it was held that a higher standard that we've talked about earlier, the higher standard of behavior or a higher standard of conduct or an additional step will not be violative of the Companies Act. As a result, if there is an additional step to be taken by the shareholders or the investors, or the company for that matter, for further issue of capital, in spite of the fact that the Companies Act is silent upon this, it does not matter, it is still enforceable, right? Now, at this point of time, we should also talk about what's known as fall away provisions. Now, what happens when an investor's equity or shareholding percentage falls greatly, right, over time? So let's say our investor originally invested at, let's say, 27%, and over successive rounds of investment by other investors, our investor number one's investment has been diluted down to, let's say, 5% or 10%. The question is, at this stage, does it make sense for that 5% investor to have the same rights, to have the same kind of power or control in the company as that investor had when it was at 27%? So what we are seeing nowadays is that there are provisions in these articles or these investment agreements or these shareholder agreements which say that um, if the investor's percentage falls below 5% or 10% or 15%, right, the investor will no longer have certain rights, and these certain rights will be kept in abeyance or in suspension or will be removed in its entirety, right? And then they enumerate what those rights are. So, for example, it doesn't make sense for a 5% equity investor to be able to stop, to be equated with the likes of somebody who's holding, let's say, 28%, right? They both can stop a special resolution. So does it make sense for a 5% equity shareholder to be able to stop a special resolution? Maybe not, right? Does it make sense for a 10% equity shareholder to have a board seat? Depends upon the size of the board, right? So if you have, let's say, 10 people on the board, 10 directors, one of those directors can be of this investor holding 10%, right? So oftentimes we will come across clauses that take away these special rights from investors if their equity is diluted down to a great extent. Now, what happens when there is a further investment or a further issue of capital, but at a lower valuation, right? Let's say our investor invested as part of round one and got 30 rupees a share as valuation. A couple of years have passed, and in round two, the company is issuing further capital again, and this time the fair market value of the company is 20 rupees a share. Now, let's say I bought 100 shares at 30 rupees a share, which means that I would have paid 3,000 rupees. Now, that 3,000 rupees has been reduced to 2,000 rupees at 20 rupees a share. Now, this obviously results in a lower shareholding valuation for our round one investor. How did this happen? Obviously, something has gone wrong with the management of the company, right? As a result, most investors will want to put in an anti dilution clause which will protect them or compensate them against such down rounds, right? Now, there are multiple ways of mitigating this down round risk. We'll briefly touch upon two of them, but we'll talk about them more in the tutorials this week and next week. The two major methods for anti-dilution clauses. The first is called a full ratchet, in which the loss to the investor is calculated as a difference between the round one and round two prices divided by the round two price, right? So in terms of the percentage increase or the percentage decrease of the between round one and round two. However, the weighted average method is far more, so the full ratchet method is considered to be far more onerous and difficult for the company and the promoter to bear. On the other hand, the weighted average method is is far more balanced and fair, right? In the opinion of many M&A and private equity lawyers. Now, the weighted average method takes into account the price of the shares both at round one as well as round two. It also takes into account the share capital, the paid up share capital before round one and the paid up share capital after round two, right? So it takes into account what was the weight of these shares in round one versus the weight of the shares in round two, which is why we call it the weighted average method. Now, in the full ratchet method, this weighted average is not taken into account. We look at absolute costs or absolute values of 30 rupees and 20 rupees a share. We'll discuss this more in detail in our tutorial. This is a fairly complicated sort of clause to draft or understand. Now, when the investor has invested in the company, the very nature of Indian businesses is that they are either individual run or they are family run. In either way, there is a very strong central presence in the business, right? This person known as the promoter, right? Now, the promoter can bring a substantial bit of expertise, can also bring the promoter's network, the social network or the family network that the promoter has. In other words, the investor is investing in the company not just because of the company itself, but also the promoter, right? Now, what it does is, what the investor will therefore want is that while the investor is a shareholder in the company until the investor sells out, the promoter should not be able to sell its shares. In other words, the promoters ought to be locked in. Now, for promoters, this doesn't matter because they consider the company as their own baby, as their own child, and they wouldn't be thinking of selling out their shares in any case. So this isn't very contentious. However, the promoters would also want some kind of stability in terms of the shareholding of the company. So they will also require, typically, that investors not be able to sell their shares for a minimum period of time, right? So investors are also typically locked in anywhere between 2 to 3 years after their investment. So at this point of time, you will have what we call a complete share transfer restriction, right? So nobody can sell their shares. However, after the lock-in period has been lifted, right, investors are allowed to sell their shares, but subject to partial restrictions. Now, these partial restrictions are in the form of either a right of first offer or a right of first refusal, right? This allows the promoters of a company to participate in the potential sale of shares by the investor. So we are now at a situation where the investor has been invested in this company for a number of years. Now the investor wishes to sell its shares. So we have over here our investor, the gentleman on the right, and these three other promoters. And this lady on the left is the main promoter. And all of them together are shareholders. So our investor over here says, I want to sell my shares. Once he says that, he turns to the promoter to say that. The promoter says, well, I will offer you INR so much for each share. So now this is a first offer that has been made to the investor by the promoter. The investor has not received or has not invited any offers from third parties yet. But now that we have our first offer, the investor will then go to a buyer and will say, will you give me X rupees for each of my shares? The buyer can say either yes or no. Let's see what happens when the buyer says no. Says no, that's too much. In which case the shares of this investor will go to the promoter, right? Now, the reason for this is that the investor knows that if this buyer has said no, if the market has said no, that the investor will not get a better price for its shares. Therefore, it sells its shares to the promoter. Now, this mechanism of a right of first offer is slightly disadvantageous to the promoters in the sense that we'll see how it is. So if this buyer had said yes, right? So let's take a look at what happens if the buyer says yes, right? So the investor says, I want to sell my shares, makes an invitation to offer to the promoter. Promoter says, I will offer you X rupees per share. And the investor then goes to the market and says to the buyer that, will you give me X rupees for each of my shares? The buyer says, yes, I will. And right here is your offer and acceptance, in which case the shares of the investor go to the buyer. At no point of time in the entire transaction between the investor, promoter, and the buyer does the promoter know the identity of the buyer. What if this buyer was a competitor of this company? Now, this buyer would be a shareholder in the company and might create trouble for the rest of the shareholders or the company as such. In which case, the right of first offer tends to be slightly disadvantageous to the promoters. A variation of the right of first offer is the right of first refusal. In this case, again, we have the standard model. We have our investor over here. We have our three promoters over here. And the investor is already in touch with our buyer, and he seeks an invitation to offer. So he says to the buyer, I want to sell my shares. The buyer says, I will offer you X rupees per share. Now, with this information, the investor turns to the promoter and says, I'm selling my shares to buyer A for X rupees a share. Are you all right with that? And the promoter says, if the promoter chooses to agree to this, the promoter says, I will match the price, in which case the shares that the investor has goes to the promoter, right? In this case, of course, the promoter has said, yes, I will match the price, I will buy the shares from you. What if the promoter had said, no, the price is too high? Then in that case, again, going through the same process. The investor tells the buyer that I want to sell my shares. The buyer says, I will offer you X rupees per share. The investor then turns to the promoter to say, I'm selling my shares to buyer A for X rupees a share. Will you price match? And the promoter says, I can't afford that price. Go ahead and sell it to buyer A, in which case the shares that the investor has goes to the buyer. In both of these situations, in terms of the right of first refusal, the promoters know who buyer A is. And this might form a factor in whether or not they say yes. Now, if this buyer is not a competitor, they can choose to not quote a higher price. However, if this person is a competitor or somebody that they do not want in the company, that might be one of the incentives for the promoters to quote a higher price than the buyer, right? So, in other words, a right of first refusal is a lot more beneficial for the promoters. However, it is not so beneficial for the investors. The reason being that when an investor has sought an invitation to offer, let's see over here, has sought an invitation to offer, and an offer has been made, the investor cannot complete or accept this offer until it has been refused by the promoters. So, in other words, the right of first refusal is with the promoters and not with the investor, right? So, both the right of first offer and the first refusal prevent the investor from transferring its shares out entirely and act as partial share transfer restrictions. There are other share transfer restrictions in the form of selling share adjustments. So let's look at how that works. Sale share adjustments. There are two kinds of adjustments that can be made. The first is a drag along right. The second is a tag along right. Now, when the investor is selling its shares, the investor has the right, but not the obligation, to ask the promoter to sell some or all of its shares. Let's take an example. Let's say the investor has 23% shares. Now, if the investor has 23% shares and the buyer, the third party buyer from the market, says that, well, 23% isn't good enough for me, I want 26%. Where is that additional 3% going to come from? If the investor has a drag along right, then the investor can turn to the promoter and say, I want you to sell 3% of your shares as well. In other words, the promoter's shares are being dragged along when the investor is selling its shares, right? That's a drag along right, where the promoter is forced or required to sell all or part of its shares at the same price to the same person, to the same buyer, and under the same conditions as the investor. Now, the reverse of that is the tag along right. Now, while most promoters are locked in for the duration of the investor's stay in the company, oftentimes the promoter might have got an offer from a third party buyer, an offer that is too good to refuse, in which case the promoter may choose to sell its shares in the company, of course subject to consent, if any, required by the investor. Now, when the promoter is selling its shares, the investor might say that, look, I trusted you as a promoter, but you're selling your shares to a third party buyer. I may not trust the third party buyer as much, and therefore I will also want to sell my shares along with you. In other words, the investor is tagging its shares along with the sale of the promoter's shares, right? And this way, the investor gets an exit at presumably what is a good price to exit at, right? So these sale share adjustments take place after the right of first offer and the right of first refusal are extinguished, and they could either be a drag along right or a tag along right depending upon who is selling the shares, right? Okay. Are these enforceable? Now, we know for a fact that the lock-in is a complete share transfer restriction, while the ROFO, ROFR, and in a way the tag and drag, they are partial restrictions, right? Now, the law is fairly clear on this. In the celebrated case of Messer Holdings versus Shah Madan Mohan Ruia, the Bombay High Court rules that any share transfer restrictions between parties are enforceable as long as the share transfer restrictions are mentioned in the articles. And this seems to be an accepted position in law. Now For public companies, this becomes even more interesting because we are allowed to restrict the transferability of shares in private companies. In public companies, you really can't have share transferability restrictions. However, the proviso to Section 58(3) in the Companies Act says that parties may enter into arrangements or contracts which will be enforceable as long as they enter into these contracts by themselves. This need not be in the articles, and they are just enforceable as contracts and not as matters of corporate law or company law. All right. And of course, we know for a fact that under 58(1), if the transfer is not in consonance with the articles, then the board must summarily reject that transfer, right? And that is the power the board has under Section 56. So this was it on share transfer restrictions, preemptive rights, tags and drags. Of course, we'll discuss this more in the tutorial. I'm going to close out this video here. In the next video, we will talk about exit rights and preferred payouts on liquidation.